Welcome back. We will now hear our next witness, Mr. Herrera. Welcome, Mr. Herrera. To introduce us briefly, this is a tribunal in this case. I'm sitting here with Professor Tawil and Dr. Bernardes. My name is Inka Hanefeld. You have been called as witness in this proceedings by claimant, so I need to ask you to read out the declaration under 35.2 of the exit arbitration rules, which should be in front of you. Could you be so kind to read it out to us?
Good afternoon. I solemnly declare upon my own conscience that I shall speak the truth, the whole truth, and nothing but the truth.
Thank you very much, Mr. Herrera. Now we come to your witness statements. Do you have your witness statements CWS 12 and 22 in front of you?
I do have both witness statements before me.
And can you confirm that these are your witness statements and that they correspond to your recollection?
Sí son mis declaraciones.
Yes, these are my statements. They have been prepared on the basis of my recollection.
Thank you very much. Then we hand over to claimant, who will ask you some questions. Then the respondent will ask some questions, and we may have questions at a later stage. Thank you.
Good afternoon, Mr. Herrera. Thank you so much for joining us. I'm going to ask you a couple of questions. Could you please describe your role and your involvement in the negotiations of the U.S.-Peru TPA?
In the negotiations of the trade agreement with the U.S., I was appointed as leader of the negotiating team for the investment chapter. The team was made up of officials from different agencies. I came through Pro Inversión. There were people from the Ministry of the Economy, the Ministry of Trade, from the Foreign Office. There were lawyers and economists. Behind us, we had a team of lawyers that supported us at all times. I participated in all of the negotiation rounds except for the last one, because at that time the negotiation of the chapter had been all but concluded. I also participated in coordination meetings with the Andean countries and in the virtual meetings that were held with the United States for coordination purposes, and also some negotiations that we had in the interim.
Can you explain how the negotiations progressed from multilateral to bilateral?
Initially, indeed, the negotiations were multilateral in nature with Ecuador and Colombia. We held coordination meetings to define a negotiation strategy. On that basis, we found common interests, and we also saw that there were some discrepancies and some internal discrepancies amongst us. So from the very beginning, we understood that there would come a time during the negotiation when the countries could start bilateral negotiations. That is what happened, indeed, and Peru at one point in time saw fit that to end the negotiations in an opportune manner, it was important to have bilateral negotiations.
In your witness statements, you testify about your understanding of several provisions of the TPA. Based on your understanding and experience, when does the limitations period under Article 10.18.1 begin to run?
The limitations period, the 3-year limitations period, started to run when the investor gains knowledge of the fact that a violation measure was taken and that measure has caused damage. A measure may create a specific harm, and for each head of damages, there is a specific limitations period applied to it.
You also testify about the fork in the road provision in Article 10.18.4 for investment agreement claims. Could you explain the U.S. and Peru's initial negotiation positions and how they came to eventual agreement on the language "same alleged breach" in the provision?
The fork in the road provision, or bifurcation as it's also known, was a mechanism that the Andean countries sought from the very beginning. Our concern was that we could face in international tribunal the same claim that could have been submitted previously in local courts. This was shown in one of the draft texts of the chapter, and this was kept during a period of time. We asked for an election, a forum that would be exclusive and definitive, and also the idea of res judicata was put to the negotiation, but the U.S. never accepted this. The U.S. said that it wanted to provide the most protection possible and access to international arbitration to its investors. And when we were negotiating the acceptance of this idea of an investment agreement, the United States restricted the concept of fork in the road. So the same violation claimed before local courts, local fora, could be then transferred to arbitral tribunals.
Could you explain what kind of adjudicative bodies the fork in the road provision covers when it mentions administrative tribunals and other binding dispute settlement procedures?
When we were discussing the fork in the road concept, we had a concern that both parties had, which was for the local fora to have the same level of independence that the International Arbitral Tribunal would have. On the other hand, when dealing with the possibility of violation of the contractual obligation, what was sought was for the forum looking at these disputes would be capable to resolve issues related to contract violation. The natural challenge was a civil court, we thought, but we also thought that a contentious adjudicatory tribunal could be an alternative for some cases to be put to it and solved by it. We also thought that there was a need to preserve the possibility that the investor may have to go to settlement dispute resolutions mechanisms that would be included in the agreements entered into between the state and the investor. That is to say, commercial arbitration under Peruvian law.
Can you please explain the negotiation history behind the non-retroactivity provision in Article 10.1.3 and the parties' understanding of the final provision?
From the outset, the Andean countries were seeking to have the investment chapter, specifically the dispute resolution mechanism, to be applied only to disputes derived from acts or events that took place after the treaty had entered into force. The U.S. was not in agreement. The U.S. was saying that if the investment chapter, as established by Article 1st, well, if the investment chapter is to be applied to measures taken by the states, then the dispute resolution mechanism had to be applied to the measures taken after the treaty entered into force and that caused damage after the treaty entered into force. There was a lot of discussion on the language of the paragraph, and then the final conclusion reached was that the best thing to do was to apply the provisions of the Vienna Convention.
In your witness statements, you explained that you discussed the reliance requirement in the investment agreement provision, Article 10.16.1. You discussed this with the U.S. delegation because they initially proposed the language in that provision. Can you describe Peru's understanding of the provision after that conversation with the U.S.?
Indeed, everything related to the trade agreement was very important for us. That is why we sent an email to the U.S. delegation for them to explain to us in a detailed manner how that paragraph would apply. The reply was that the paragraph was to be understood by reading it in a comprehensive manner under the definition of investment agreement and under the definition of covered investment. Our conclusion was that the investment agreement may be signed by an investor or by a company, by a local company. That was the most common case for Peru. Secondly, the reliance requirement could be met by the investor or by the company. The important thing that was highlighted was that the claim had to be directly related to the investment and the damages caused to the investment that was carried out in reliance of the investment agreement.
And based on your understanding, is there a temporal limitation in Article 10.16.1?
There isn't. No mention was made of any temporal limitation under 10.16.1. This was of great concern to us because we always understood, and the U.S. always put this to us, that the coverage on investment agreements had to do with those agreements entered into when the treaty came into force, and also it had to apply to the investment agreements or contracts that may qualify as investment agreements subscribed before the treaty entered into force. Peru, at one point in time during the negotiation, suggested that perhaps a waiver could be included so that the chapter would only include the investment agreement signed 2 years after. Chile had done something like that. The U.S. said no, and there was a parallel negotiation with the Central American countries that the U.S. was having parallelly, and they were considering the possibility for the chapter to only apply to agreements entered into from the entry into force of the treaty. Well, in the case of the Andean countries, and specifically in the case of Peru, they said, no, it's impossible. All of the existing agreement need to be covered. The problem was that at that point in time, there were contingencies related to some contracts made by the government with U.S. investors. So the investors were worried, and this was a worry that was taken up by the negotiators.
Thank you very much, Mr. Herrera. Madam President, I have no further questions.
Thank you.
Good afternoon, Mr. Herrera. My name is Jennifer Haworth McCandless. I'm part of the team that represents the Republic of Peru in this arbitration. And I think we've met before in Peru because you're a member of the commission, the special commission that represents Peru, I think at one point in time. I remember meeting you in Lima. And I am going to be asking some questions about your witness statements. Obviously, I'll be asking them in English, and you, I understand, will continue testifying in Spanish. So we'll need to both take a pause, but you were doing an excellent job with counsel for claimant with respect to not talking over her. So you and I may be able to accomplish this if I pause after I do my questions and you pause before you give your answers. I think we both have the translation, so we'll both be able to understand when the translation has stopped. But you are in agreement with acting accordingly?
Good afternoon, Jennifer. It's a pleasure to see you. Yes, of course.
And similarly, if I pause, as I will in order to allow for the translation to finish, I am not inviting you to continue with an explanation. I am just waiting for the translation to finish. Okay?
Very well.
We're passing out. You should have a binder in front of you with some of the documents to discuss during this cross-examination. So I want to first talk about the process that you undertook in writing your witness statements. Did you yourself write your witness statements?
Yes, I wrote my statement.
You state in paragraph 2 of your first witness statement, I think it's also in your second witness statement, but I'll read the first witness statement. You say, counsel for Freeport and Sociedad Minera Cerro Verde assisted me in preparing this statement. So what you stated just now, that you wrote your witness statement, is inconsistent with that statement that counsel for claimant assisted you. Is it that you wrote your statement, or did you work with counsel for claimant to write your statement?
Yes, indeed. I prepared my statement with the assistance of counsel.
How did you work cooperatively with counsel for claimant?
Counsel for claimant provided documents to me for me to be able to prepare my statement. I was given a binder with documents on the Ministry of Commerce reports, for example. Also, a number of drafts of the investment chapter, some emails that had existed during the negotiation back then, and some other documents that were submitted by Peru as well.
We'll talk about those documents that counsel for claimant gave to you, but I was talking more about the process of writing the witness statements. Could you please explain that process, please?
Yes, of course. I prepared drafts of the statement, and I sent those drafts over to the law firm, and we came to a final language.
Sorry, I have to turn up my volume so I could hear in translation. You were the primary author then of your written statements, and you gave it to claimant, or did they write a draft and give it to you to review?
I prepared my comments in connection with each one of the points. They formatted everything, and I reviewed the final version.
And just, you have stated in paragraph 12 that you're an economist. Is that correct?
Yes, I'm an economist.
So you're not a lawyer, correct?
I'm not a lawyer, no.
In paragraph 4 of your first witness statement, you make a reference. You say, I understand that a treaty must be interpreted in good faith in accordance with the ordinary meaning to be given to its terms in their context and in light of the treaty's object and purpose, and that in certain circumstances a treaty may resort to supplementary means of interpretation, including the preparatory works to the treaty and the circumstances of its execution. Did you write that?
No, really. No, I did not write that phrase, but that is a phrase that it sounded to me as a very common phrase because of my experience in negotiations with the United States in connection with this treaty, and also other investment chapters that I assisted with in negotiations with other countries.
Yes, it sounded rather lawyerly-like. So since you're an economist, I thought perhaps you did not write that text, and you confirmed that. You say that you carefully reviewed the final Spanish versions of your witness statements, and you confirmed that they reflect your independent memory and understanding. Is that correct? You stated that, I believe, in paragraph 2.
Yes, indeed. This document reflects my recollection and understanding of the negotiation process.
I assume that when you state something in your witness statement that you, for which you have contemporaneous documentary support, that you cite to it in support of that, correct?
Yes, indeed. This statement reflects my recollection. When I prepared the first drafts, I reflected in there my recollection, and I supported that on documents provided to me by counsel, as I mentioned, when I had certain doubts.
Yes. You state in paragraph 1 that whenever you testify on subjects beyond your personal knowledge, you identify the source of the information and the basis of your understanding, correct? And you stated that, I think, also in your second witness statement.
Responda.
Como
Yes, of course. As I said, when I had a doubt, I went to the documents that were given to me.
So to be clear, you are admitting, and you admit in your witness statements, that you are testifying on issues in some circumstances beyond your personal knowledge. Is that correct?
My statements are based on my recollection and everything that I went through during the negotiation as the head of that negotiating team. Undoubtedly, there are some concepts that I wasn't really an expert on during the negotiation process. I was not a lawyer, and we had lawyers that were specialists and provided support to us in that regard. So, in the prep team, we had a lawyer that was a specialist in international law, for example.
So is the statement that you have in your witness statement is correct, that you are sometimes testifying on subjects beyond your personal knowledge in this witness statement? Is that correct? Or do you wish to change your witness statement?
No, I don't want to do it anyway.
This, your witness statement includes, you talk about subjects that are beyond your personal knowledge, correct?
I provide a statement of things that go beyond my personal and professional area.
Okay, so the answer, I think, is yes. And you, in that case, when you say that when you're talking about issues that are beyond your personal knowledge, you identify the source of that information and the basis of your understanding by citing to those documents. But if you also, as you testified shortly before, cite to documents on which you have, on situations or statements in which you do have personal knowledge, how is a reader supposed to understand if the documents that you're using are based on your personal knowledge or not based on your personal knowledge?
The document is based on my personal knowledge and the recollections I have of the negotiation.
But on topics in which you don't have a personal knowledge you're citing, and on topics that are your personal knowledge you're citing, so how is one supposed to derive whether or not the statements are based on your personal knowledge or not?
There are specific aspects that undoubtedly I am not an expert on. There are legal aspects that I'm not an expert on. I refer to those in a general manner. I do not really discuss them in depth. It would be unethical. I don't have the ability to discuss those things, but I do make reference to them because they are part of my recollection and the memories I have of the negotiation.
Okay. I'm not sure I'm going to get a clarity on that, but perhaps when you say when you discuss things and you're like, I recall or I understood, that maybe that's reflecting your own personal recollection, and when you're saying something more general, then that's perhaps not your personal recollection. Would that be fair?
I think that you understanding this in a very convoluted manner. Indeed, there are times where I refer only to what I recall, and I don't really delve into legal issues.
And you state in paragraph 5 of your first witness statement and also in your second witness statement that you relied, and you discussed it also just a few minutes ago, that you relied on contemporaneous summaries of the TPA negotiation rounds prepared by the Ministry of Foreign Trade and Tourism, or MINSATOUR, emails between U.S. negotiators and yourself, and drafts of the U.S. Andean Free Trade Agreement and the TPA. And we'll discuss in a few minutes those documents, but I wanted to confirm that these were documents on which you relied in writing your witness statements. Is that correct?
Yes, indeed.
And you state in paragraph 7 of your first witness statement that you worked as a government official in Peru from 1976 to 2001. Is that correct?
Perdón, ¿en qué?
I'm sorry, where do I say that? At which paragraph?
Paragraph 7 of your first witness statement. You state that you worked as a government official in Peru from 1976 to 2017. Is that correct?
Sí, hasta
Yes, until 2017.
I didn't think that was going to be a complicated question, but that's okay. It's a long period of time to remember. And you state in paragraph 10 of your first witness statement that from 1997 to 2013, you were the leader of the Peruvian delegation negotiating bilateral investment agreements and investment chapters of the TPA. Is that correct?
Yes. In effect, I was in charge of the negotiation as team leader in many cases, and in some others, I was a member of the negotiating team in several meetings and in several trade investment agreements or investment treaties.
And you held that role in your capacity working as at Proinversión as its representative to the Negotiating Commission for Investment Promotion and Protection, correct?
Yes, that is correct. Actually, my experience with respect to negotiation of international investment agreements comes from before my time in Proinversión, when I would participate at the National Commission of Foreign Investment and Technology, which is when Peru began to negotiate bilateral investment treaties.
Yeah, yes. In paragraph 14, you're saying that as Proinversión's representative to the Negotiating Commission, I led the Peruvian delegation in the negotiations of the investment chapter. So that's how you've characterized it. Can you please describe the internal process conducted in Peru to adopt an official position in the negotiating process?
Yes, of course. As I indicate there, a negotiating commission had been established for negotiating international investment agreements, both bilateral and, when it was decided to begin the negotiation with the United States, also the free trade agreement in the investment chapter. As I mentioned initially, the team was made up of representatives of the Ministry of Economy, the Ministry of Trade, the Foreign Ministry, and Proinversión, which presided over or chaired the commission. So we had internal coordination, but also coordination with other sectors, particularly for the treaty with the United States, to determine the non-conforming measures that we would have to address.
So it was an interagency process. Is that how you're describing it? It's an interagency process. It involved more than just one agency, correct?
Yes, in effect, there was coordination among the different agencies.
And it's possible that members of that interagency, the interagency representatives, they might disagree with something, say that you were negotiating or that your team were negotiating. It is possible that there were disagreements among the members of the different ministries in the interagency process, correct?
Yes, indeed, on some occasion. Let's say that I was too careful or cautious on issues in respect of which other institutions wanted to yield more quickly in the negotiation.
And was the Ministry of Economy and Finance the lead agency in charge of the investment chapter of the TPA?
Yes. Actually, the Ministry of Economy was a coordinating entity for the negotiation of several chapters that were within the scope of its competence. One of these investments, also financial services, and others.
The MEF, Ministry of Economy and Finance, formed the Negotiating Commission for Investment Promotion and Protection, and that's what you chaired, correct? So you were working underneath the umbrella of the MEF, the Ministry of Economy and Finance?
Yes, that's right.
And did you personally make the final decisions regarding Peru's official position in the negotiation, or did you report to somebody at the Ministry of Economy and Finance?
All of the positions were coordinated among the different agencies, and specifically, in the case of the investment agreement, there was direct coordination with Minister Zavala and also with Minister de la Flor.
Perdón, el ministro.
I'm sorry, Ministry of Trade.
Do you know Javier Illescas? He's the Director of International Economy. Did you report to him?
Yes, I've known Javier Illescas for a long time. I have not worked under him at any time, but Javier Illescas was part of the negotiating team. He was the coordinator for the MEF of the discussion tables that were under of its competence, but was not participating directly in the negotiations at any time, at least not on investments. But yes, there was a representative from the MEF.
Did you discuss with him? Did you report to him on issues that you negotiated? You were negotiating?
All of the coordination, or most of the coordination, was through the MEF representative on the team. But on occasion, I did have direct meetings with Javier Illescas.
And did the negotiating commission keep its own meeting minutes or notes or writings or about regarding the negotiating rounds for the TPA?
There were never official minutes of the meeting, but the members of the negotiating team, we would generally take notes, which were then compared, plus each one would provide a report on their own participation in the round that was forwarded internally to their own agency, and then it was all consolidated by the Ministry of Trade.
So did you, you probably don't, but do you have access to any of those documents, the ones that weren't necessarily fed up to the Minsator, but the documents that reflected the more immediate notes or informal, you said it wasn't formal, but that you would have taken perhaps in the negotiations?
Yes, we would generally exchange the notes that we would take. So I have some of the notes because I actually lost a lot of files because of a computer problem at one point in time.
So you have those personally you have those? I mean, you're no longer working for the government, but you have copies of those notes. Is that what you're testifying?
I have the archives of notes that I personally took that stayed in my computer. They are not official notes. They were used for me to draw up the official reports that were presented to Pro Inversión, Ministry of Economy, and Ministry of Trade.
Review those notes prior to writing your witness statements here for this arbitration?
Yes, on some occasion, I reviewed the notes because, as I mentioned, sometimes you might remember things one way, but you're not certain, and so I looked to see if I had any notes in regard to certain issues so as to be able to confirm my recollections.
But I don't recall seeing anything like that cited in your witness statement. Did you cite to any of those? Did you have them placed on the record?
No, actually I did not, because, as I say, these are notes that have no official value, and the summaries that were provided to me from the Ministry of Trade already have the comments of those notes.
They're not official notes, but nevertheless, you said you consulted them to write your witness statement. So why didn't you give those notes to counsel for a claimant to add them to the record?
I did send the notes that I had to the lawyers.
Question. Whether you gave it to your counsel, I assume that you hadn't. Okay, so you gave notes to the counsel for claimant, but they're not on the record. And you said in paragraph 5 of your witness statement that in preparing your witness statement, you relied on, and you itemize it, contemporaneous summaries of the TPA negotiation rounds by the Ministry of Trade, Foreign Trade and Tourism, posted on the ministry's website, emails between the U.S. negotiators and myself, and drafts of the U.S. Andean Free Trade Agreement and the TPA. And you don't state that you relied on your own notes, and you don't even qualify this by saying, among other things. So do you want to amend that testimony in your witness statement in paragraph 5 to indicate that you referred to other documents that are not on the record in preparing your witness statements?
Personally, I don't think it's necessary because, as I say, those are non-official notes, and they're already reflected in the summaries of the Ministry of Trade.
Sorry. It just states that in preparing your witness statement, you list 3 different sources. It's not the fact that they're your own personal notes and not official is irrelevant to the question of what you relied on when you wrote your witness statement. Do you wish to amend your witness statements and state that you relied on additional documents in preparing your witness statements?
I really don't. As I said, the statement mainly reflects my memories of the negotiation process, a process in which I was involved completely. And those notes, at any rate, I have not taken anything from those notes that would not be reflected in the official documents. It was just to confirm some of my recollections.
Unfortunately, we won't be able to test that because we haven't seen those. In paragraph 4 of your first witness statement and in paragraph 5 of your second witness statement, you state that your statements are based on your personal experience as a negotiator of the TPA on behalf of the Peruvian government, correct?
Yes, that is correct.
And you also state that you do not quote in paragraph, same paragraph, sorry, yes, that you do not purport to speak on behalf of Peru in preparing in your witness statements, correct?
Clearly, I'm not speaking on behalf of Peru. I am reflecting what I experienced in the negotiation process as the head of the negotiating team.
But you are testifying in your witness statements about what happened in the discussions with the United States when you were negotiating the TPA, correct?
Yes, indeed.
And you are discussing what you did as a government official on behalf of Peru during the course of the negotiations. Did I get that right?
Yes.
And did you consult with your former employer to get permission to testify regarding the negotiations with the United States regarding the TPA?
No, I have not asked for permission from the government to provide testimony. As far as I know, there's nothing that would impede me from doing so.
Did you think about whether you needed to get permission?
Actually, at some point in time, I said, well, I've worked for the state. I'm going to provide a witness statement. The witness statement's based on my recollections as a public official at that time. I am going to say what I saw. I'm going to reveal what was discussed. And I didn't have any reason to seek permission.
Did you consult with someone about whether you needed to get permission?
No, I did not consult anyone, but I did tell some officials that I was being hired by Freeport's lawyers.
Did you reach your conclusion that you were free to testify about the negotiations between Peru and the United States regarding the TPA?
Because there is nothing that establishes such a limitation in Peru.
Are you aware of a provision in the Texto Único Coordinado of the Law 27806, which is a law on transparency and access to public information?
Objection, the document is not on the record.
It's not on the record, but I'm asking him his knowledge of it. I'm not asking about the content. I'm just asking if he's aware of this. And that's a perfectly
Perhaps
possible
it would
thing
be
to
helpful
ask.
to show him the document then.
I would just want to ask his knowledge if he's aware of it. That's my question. So, but I want to go through and say what the document says.
If claimant could just be heard very briefly on this.
As you may imagine, I also do not know this law and these provisions, so please keep in mind that you also have to keep us with you.
Yes, it's just a single question. Are you aware of a provision in the Texto Único Coordinado, which is law number 27806, which is the law on transparency and access to public information, which provides exceptions for the right to have access to information held by public entities, including elements of international negotiations, where disclosure of this information would harm the negotiating process or alter the adopted position of the state? Are you aware of that law and that specific provision?
No, as I have said, those notes are not official. I am not keeping any official document of Peru from the time of the negotiation process. They are personal comments regarding my personal understanding. Moreover, what one can find in my statement is only what is reflected in my personal documents. That is to say, the official documents from the Ministry of Trade and the negotiating history, which is in the different draft versions, in the emails. That is what is in my statement, and it is cited very meticulously.
And are you aware that by testifying in a manner inconsistent with the state's official position, that there is a risk that that testimony might alter the adopted position of the state and therefore disclose information that might be prohibited?
Madam President, if there were any concerns about that that should have been raised before, I mean, what's happening here is that the witness is being intimidated, and that's entirely inappropriate.
The witness is not being intimidated. I'm just asking some questions.
Respondent knew for several months, in fact, more than a year and several months, that Mr. Herrera is testifying. If there were any concerns, they should have been raised appropriately, and not when the witness is sitting here. What's happening here is witness intimidation, and it's entirely inappropriate, and I object in the strongest terms against that.
Take note, Mr. Prager. What is your comment on that?
Oh, I obviously disagree. Respondent has called Mr. Herrera here to cross-examine him, and this is the point in which we're cross-examining and probing what his testimony is about and whether he's appropriately here to be testifying on behalf of Peru or not. It's a perfectly appropriate line of question for someone who submitted a witness statement who was a former government official and is now testifying against the state, and to probe whether or not what he's actually testifying about and whether he is aware that that is potentially inconsistent with Peru's official position in this arbitration.
The tribunal will briefly consult and then come back to the room.
I just wanted to add that he's not here on behalf of Peru, so I wanted to have that clarified.
But he's testifying on the negotiations when he was an official of the government of Peru in those negotiations. It's hard to separate those two.
Mr. Herrera, I apologize for this short break, but we just wanted to now reach consensus on how we want to proceed. We have heard what Anna, your concern was on respondent side. We have heard your objection, Mr. Prager. We would like you to move on with the next topic.
Absolutely, Madam
President, if I might still, just for the purpose of the record, add that at no point has respondent requested that his testimony or his witness statement be treated as protected information under this in this proceeding under the TPA, and they would have had the opportunity to do that.
You made your point really clear, and we have understood that. And Mr. Herrera, I hope you feel still comfortable testifying. Do you?
Yes, ma'am. Thank you very much.
We proceed with the next line of questions.
Thank you, Madam President. And as you discussed in paragraph 5 of both of your witness statements, and as we discussed a little bit earlier today, you state that in preparing your witness statements, you relied on contemporaneous summaries of the TPA negotiation rounds prepared by Minsator, and also on emails and drafts of the negotiations provided by counsel for Freeport, correct?
Yes, that's correct.
Paragraph 5 of your witness statement, you also indicate that you understand that those emails and that those negotiations, drafts of negotiations, were obtained through a request under the U.S. Freedom of Information Act. Is that correct?
Yes, that's what I was told by the lawyers.
And with respect to the documents that you received from counsel for Freeport, did you talk with counsel before they submitted their FOIA request to the U.S. government to give input on what they should be asking for in order to make sure that the documents that they received reflected your negotiations?
On the grounds that the opposing counsel is asking the witness to reveal privileged communications between the witness and counsel, and there is actually a privilege protocol agreed between the parties in this proceeding that protects precisely that information.
Madam President, this is not asking anything that's privileged. I'm asking whether he was consulted by the lawyers before they submitted their FOIA request. That's hardly privileged information. It's just, did he have any input in when they were submitting their FOIA request and identifying what the FOIA request was, the scope was? Did he have any input? That's not privileged information.
That goes directly to counsel's legal strategy in developing the evidence to be submitted in this proceeding.
I'm not asking about the content. I'm just asking if he provided any input.
So it's just about the question whether there was some communication and not about the content?
He gave any input to determine the scope of the FOIA request. That's it. That's my only question.
Madam President, if I could just read to you from the privilege protocol that was agreed to between the parties in this proceeding. It says counsel is asking, it says communications between witness and counsel, and pursuant to section 3.1, those communications shall not be disclosable in the arbitration.
Madam President, I'm not asking for the actual content of the communication, just the fact of whether he was consulted. That's my only question on that issue.
So put now this provision on screen, because my transcript is not complete enough. When we have to make a decision on whether this question is now legitimate or not, I need to see the legal basis for our decision.
Yeah. If you could give us a moment, we can print out copies of it. Otherwise, we would need control of the
to be honest, it's really unfortunate. We and I want to avoid such debates here in the hearing room in front of the witness. We want to hear what the witness has to testify. So does both parties wish to continue this debate? Or can we avoid it by permitting the question whether there was a consultation, yes, no, move on, go to the next topic?
that's fine from respondent's perspective.
We're in your hands, Madam President. We would prefer for the opposing counsel to move on from this line of questioning.
I don't have, it's not a line, it's a single question. That's my only question, and I will move on after I hear his answer.
Yes, please move on. Let us avoid such debate.
Yes, after you hear your answer. If you could please answer the question, then I will move on.
Quite sincerely, I don't recall that I told them, ask for this or that information. What is true is that the summaries, for example, from the Ministry of Foreign Trade, well, I've seen them at some point in time on the website of the ministry. I don't know if they're still there, but at some point in time, I recall they were at the ministry's website. Yes, it says published at the ministry's website. Drafts of the FTA. Well, I've been provided with some of these. I recall that there were many more, but I have not asked that they specifically give me this or that document. It would be impossible. I cannot have such a specific recollection.
As we discussed earlier, from 1976 to 2017, you held various positions with the government of Peru. And now, do I understand it correctly that you work as an independent consultant since July of 2017?
Yes, that is correct.
And on what types of matters have you been engaged as a consultant?
Those are consultancies at the personal independent level. I do not have a consulting company behind me. I was working with the legal firm on some issues. It is not the legal firm that is here with the mining company. It is a different legal firm in connection, a different law firm in connection with the treatment of foreign investment in the country, steps, processes that need to be complied with. And also I work with a British consultancy firm for promoting investment on information technology in Central America. And I also worked with the local consulting firm on a trade ministry program at a different point in time. On the other hand, I am also an advisor. I provide some sort of advisory services at meetings with embassies that are credited to be in the country, and they call me to ask for opinion on various issues in connection with this.
Paid? Do you get paid by the hour for your consultancy work, or how do you get paid?
Yes, that's the way it is. I usually work on an hourly basis.
And approximately how much do you get paid per hour?
In general, $200 an hour.
And were you engaged to provide witness testimony in this arbitration? Were you paid?
Yes, I have a contract, indeed, for my work in this arbitration.
Or to witness statements and also for preparing for and participating in this hearing?
Yes, indeed.
Your hourly rate, are you being paid for this?
In this case, I am paid $250 an hour.
50?
That is correct.
Typical rate.
Yes.
And you don't, I didn't find, but correct me if I'm wrong, did you indicate that you were being paid for presenting your witness statements and testifying? Did you indicate that in either of your witness statements?
I don't think I have mentioned that.
In in paragraph 11 of your first witness statement, you state that you appeared on behalf of Peru in different arbitrations, including Duke Energy versus Peru. Is that correct?
Yes, that is correct.
Witness statements in that case, is that right?
I remember attending the hearing and the Duke hearing, and I also remember very well who examined me.
And you state in your witness statement in this submission that you testified in that case about the negotiation and execution of judicial stability agreements, correct?
Sí, es correcto.
Yes, that is correct.
And in this case, you're not talking about or testifying about scope of stability agreements, are you?
No, I wasn't asked about the scope of the legal stability agreements.
And is that because when Duke you testified that the scope of the legal stability agreement is strictly limited to specific investments mentioned in each agreement? Could that be the reason why you're not testifying here on that issue?
I'm sorry, we would just have to intervene. The witness is being asked to testify on matters that are beyond the scope of his witness statements, and that's been clearly established in PO4.
Well,
Can you rephrase your question, please?
Sure. In his witness statement, he mentions that he was submitted a witness statement in Duke Energy versus Peru regarding the negotiation execution of juridical stability agreements. So my question is, you're not testifying here about the scope of stability agreements. Is it potentially because there's an inconsistency in what you stated in that witness statement versus what is being testified here about the scope of stability agreements?
This is not a rephrasing of the. I'm sorry. This is not a change in the question. It's just a rephrasing of the same question. The witness does not testify about the scope of stability agreements in this proceeding, or about Duke Energy, except to mention that he gave testimony in that case.
I'll move on, Madam President. Turning to the TPA negotiations regarding the limitations period, in paragraph 22 of your first witness statement, you stated that based on the discussions in the U.S. with the U.S. team, it was clear to the Peruvian delegation that Article 10.18.1 referred to actual or constructive knowledge of past events. That is, for example, based on loss or damage that has been incurred and not loss or damage that could develop sometime in the future, correct? It's paragraph 22 of your first witness statement, which is behind tab 1 if you want to look at the document.
Sí, efectivamente.
Yes, indeed. The understanding that we had, and also the way in which we discussed this with the U.S., meant that the prescription, the period, had to do with the constructive knowledge of events past.
You're saying that your understanding was that 10.18.1 of the TPA required actual loss, right? You say loss or damage in the center of that paragraph, loss or damage that has been incurred. So in your view, it was loss that was actual loss, that 10.18.1 of the TPA requires actual loss. Is that correct?
efectivamente tiene
Yes, indeed. There needs to be damage. The damage must have occurred.
And in your view, that's what the U.S. delegation also understood incurred meant, because at the beginning of that sentence you say, based on discussions with the U.S. team. So I assume that your understanding was that was the U.S. delegation's understanding as well. Is that correct?
Yes, indeed. We always talk about actual damages.
And are you aware that the U.S. government has submitted a non-disputing party submission in this case, in which it states that for there to be a loss or damage, for loss or damages incurred in Article 10.18.1 of the TPA, the claimant does not have to actually have sustained a loss. And if you look at tab 4, where it's the U.S. non-disputing party submission.
Yeah, we would just ask that you read what the U.S. actually wrote in the submission, because I believe that's a mischaracterization of the U.S. submission.
I am going to show him the paragraph right now. It's paragraph 11, behind tab 4. And this is the U.S. non-disputing party submission, and in the second sentence it says, moreover, the term incurred broadly means to become liable or subject to, and there's a footnote 16 that refers to a case, United States versus Laney, in which parenthetical states, finding that to incur means to become liable or subject to, and that a person may become subject to an expense before she actually disperses any funds. Do you see that text?
Yes, I see it, and I believe that this is not in opposition to what we discussed in the negotiation with the U.S. delegation. The fact that there is no disbursement, no financial disbursement, does not imply that there was no damage.
It says before actual disbursement of any funds. If we look at the next sentence, it says, therefore, in the paragraph 11, therefore an investor may have incurred loss or damage, even if the financial impact of that loss or damage is not immediate. And there's a footnote 17, which refers to the Berkowitz case, and in parentheticals that states, finding the date on which the claimant first acquired actual or constructive knowledge of the loss or damage incurred in consequence of the breach implies that such knowledge is triggered by the first appreciation that loss or damage will be or has been incurred, will be incurred. Do you see that text as well?
sí,
Yes, yes, indeed. I see it.
Madam President, I have no further questions.
Thank you. Any questions in redirect?
No further questions, thank you.
Mr. Herrera, we also do not have questions, so you are hereby released as a witness. Thank you very much.
muchas gracias al tribunal.
I thank the tribunal and everyone in attendance, and my dear friend Stadimir. I thank you, and I just hope that my statement is useful to get to a good resolution of the case.
So, do the parties wish a short break before we continue? Probably we need a break, huh, to make the
Before
setup.
we do that, Madam President, can I raise a procedural point? So we saw a situation where one lawyer defending the witness, Ms. Wang, um, ceded the floor to Mr. Ukabiala, then Mr. Prager, then back to Mr. Ukabiala making procedural objections during the examination of Mr. Herrera. We are a bit reluctant to agree that this should be the practice where you have a row of lawyers and one after the other raises procedural objections. We need to understand what the position of the tribunal is. If the tribunal is fine with that, that's fine with us. We will then use the same practice. We have been sticking to the practice of whoever is at the microphone, either conducting the direct examination or the cross-examination, is the one to raise procedural objections in relation to the examination of that witness. If the view of the tribunal is that the practice of having 1, 2, 3 lawyers raising objections one after the other, that's fine. We just need clarity going forward.
I think we made clear that we hope not to receive any further multiple objections, so hopefully the problem will not arise again. How long do you need to get Mr. Isazi?
I think a 15-minute break is appropriate
15-minute
at this
break?
moment, if that's okay.
Then we do a 15-minute break and meet again at 3:30.
Okay. Hello again, Marissa. I believe you should be able to hear me.
Yes, loud and clear.
Yes. Thank you. Yep. And Mr. Isasi is also with us. So if we can just ask him to test his audio and video.
Hola, señor Isasi. ¿Me escucha?
Sí, un poco bajo, pero le escucho.
Probemos otra vez. ¿Me escucha mejor?
A ver, subimos el volumen acá.
Sí, claro.
¿Dónde está?
Es por favor, súbalo. Va a escuchar una tonada.
Ahora, a ver, por favor.
Ven, ¿me escucha ahora?
Sí.
Perfecto. Tiene delante de usted su declaración de testigo, ¿verdad?
Sí.
Vale. Después, cuando empecemos, la presidenta le pedirá que la lea. De momento no tiene que hacer nada.
Ya.
Interpretación.
Yep. I'm unaware if Mr. Isasi can knows how to switch between the channels. If he can just select the Spanish one.
No sé. What do I need to do now? I'm lost.
It's in their hands.
Okay. So now they have to
knows to speak.
Yeah. They have to tell him how to be in the Spanish.
Indeed, yes.
Okay.
Yeah.
Okay.
Pardon me.
You're fine. Sorry. I didn't end up using it. That one for documents, yeah. Oh my God, yeah.
Mr. Isasi, could you please confirm that you see the shared content, sir? The ICSID logo.
Si me traducen, por favor.
Yeah, sorry, my Spanish is really bad. I need help from...
No sé qué cosa me está pidiendo.
Señor Isasi, ¿me escucha?
¿Acá? Sí, ahora sí la escucho.
Muy bien. Tiene que ponerse en el canal en español.
No, perdón. Acá está, acá el técnico parece que me está orientando mal.
Explicarle tú.
Tema de interpretación que dice acá que es...
Para que ustedes escuchen el idioma.
No, es que ellos van a traducir simultáneamente.
Claro. Está español. Es para que ustedes escuchen español.
Ya. Pero yo voy a escuchar en español la traducción simultánea. Sí, pero distorsionada la voz.
Claro, porque están acá equivocados.
Señor Isasi, tiene que...
Ya escogí español.
Vale.
Pero hay un eco en lo que yo hablo, y se repite, y lo que usted habla se escucha distorsionado.
Ok, vamos a verlo. Denos unos minutos.
¿Ah? Acá dice que apague. A ver ahora. ¿Ahora me habla?
¿Sí, me escucha?
Ahora sí escucho mejor.
¿Mejor? ¿Y ha seleccionado el canal en español? ¿En Zoom? We tested everything. Que no entiendo. Ahora está. Sí. Ahora tiene el micrófono en silencio.
Le explico. Cuando
Dígame.
yo pongo interpretación y pido español,
¿Me escucha a mí?
escuchar en español,
Sí.
le escucho a usted.
Claro, porque estoy
Sí,
hablando.
le escucho, pero distorsionada. Cuando he eliminado esa opción y he puesto audio original, interpretación desactivada, sí la escucho a usted claramente.
No, pero usted tiene que seleccionar el canal en español y quedarse ahí. Denos unos minutos y le atendemos enseguida.
¿Pongo español entonces? Ya puse español y se le escucha distorsionada. Sí. Audio original. Silenciar. Silenciar audio. Están probando los técnicos. A ver, ahora. Sí, mejor. A usted. Escucho a la... se está re- Estoy escuchando al traductor, un varón, sí. Pero no lo veo. Sí.
Good afternoon, Mr. Isasi.
Recording in progress.
Good afternoon, Mr. Isasi. Can you hear and see us well?
Sí.
Yes, I'm hearing well.
Thank you. Then we welcome you as witness in this proceedings. I briefly introduce the tribunal. My name is Inka Hanefeld. I'm the presiding arbitrator in this arbitration. I'm here with my co-arbitrators, Professor Guido Terrell and with Dr. Bernardo Cremades. Can you hear me?
Sí.
There's echo. I hear an echo in here as well. But please go on, ma'am. I think I'm going to be okay. I think what I'm going to do is turn the volume down, and perhaps things are going to be a little better. Okay, go ahead. Please go ahead. Good afternoon. Good afternoon, Madam President, members of the tribunal.
Mr. Sazo, you this proceedings by the respondent. As such, you need to make a declaration under Article 35, paragraph 2 of the exit arbitration rules, in which you declare that you will state the truth and nothing but the truth.
Declaración.
So, could someone be so kind to give Mr. Isasi this declaration? Otherwise, I can also read it out to you.
No, el texto de la declaración.
He's talking to someone else. You need to give me the text of the declaration, the oath. Last time I was given a sheet of paper with it, he says. Please, the oath, give me the witness declaration. Perhaps if you can show it on the screen, I can read it, but I don't see it here.
And I speak it, and you just...
Acá está.
Okay. Screen for you, just a minute.
Procedo. Muy bien.
Shall I read it?
Declaro solemnemente.
I solemnly declare upon my honor and conscience that I shall speak the truth, the whole truth, and nothing but the truth.
Thank you very much. And then we get to your witness statements. Do you have a clean copy of your witness statements RWS 2 and 9 in front of you?
RWS2 and RWS9, yes, I do.
And can you confirm that these are your witness statements and that they correspond to your recollection, or do you have anything to correct?
I'm sorry. Is the member of the tribunal speaking to me, or is a party lawyer speaking to me?
I'm the president of the tribunal. I hope you see me and you hear me.
No le escucho bien. No se escucha.
I cannot hear you.
You cannot hear me, you cannot see me, then we have an issue that needs to be solved right away.
Recording stopped.
No estoy escuchando a la presidenta.
I can't hear the Madam President. I only hear the interpreter. And that is why it's confusing. I don't know if the president is speaking or the interpreter is speaking or a counselor is speaking.
Se supone que es una traducción simultánea.
Is it simultaneous interpretation? So I'm going to have to see who's speaking.
But can you, you do not see me now? You should see me. I see you.
Ahora sí. Ahora sí.
Now I can see you, Madam President.
But I'm only in command of English, so it needs to be translated, and you hear the translator.
That's right.
So, coming back to your witness statements, do you have anything to amend or correct?
Recording in progress.
I do not. No rectifications whatsoever.
Perfect, then we can proceed. You will now first be questioned by the Respondents' Council and then be cross-examined by Claimants' Council, and we as a tribunal may also have additional questions.
Very well.
Gracias.
Thank you.
Good afternoon, Mr. Isasi. The president of the tribunal showed you or referenced your witness statements, and you had them in front of you. Do those statements, are they based on your personal knowledge and experience?
Yes.
Could you please describe your educational background?
I am a lawyer. I graduated from the Catholic University of Peru in 1976. I also have done studies at the master's degree level in public administration at the Instituto Ortega y Gasset within the Universidad Complutense de Madrid. It doesn't have any official validation. It wasn't a course of studies here in Peru by the Continental University. I also have received training in corporate management from ESAN, the Escuela de Dirección de Universidad de Pintura en Centrum Católica, among others.
Current position?
I am a partner of the Fernandez Ruiz Sanchez Abogados.
And what positions did you hold at the Ministry of Energy and Mines?
You mean currently or?
Previously.
La traducción. Entiendo que me está preguntando.
I understand that you're asking me about the ministry.
Did you hold at the Ministry of Energy and Mines when you worked there?
I was the General Director of Legal Advisory of the MINEM between 2004 and 2007. I was the Vice Minister of Mines between 07 and 09, June 09.
And you wrote an opinion in April of 2005 about mining stabilization agreements. Could you please explain briefly why you wrote that opinion?
Are you making reference of the 14 April 2005 report that was issued by my office at the request of the National Superintendents of Tax Administration to answer inquiries in connection with the scope of legal stabilization agreements entered into by Peru. This in connection with the application or non-application of the royalties law to mining concession holders under those agreements. Just to clarify, I want to say that this was also done to clarify the Constitutional Court judgment in connection with the legality of the royalties, mining royalties law. The claimants had said that this law violated taxability. The Constitutional Tribunal said that royalties are not a tax, and therefore it is not protected by the stabilization agreements. And that is why all mining concession title holders had to pay mining royalties. If you wish, I can explain further, or if you ask me questions, I can talk about the core of my report.
And what is it that you concluded in your report?
Que no se está escuchando bien la traducción.
Yes, of course. What did you conclude in your
¿Puede
report?
repetir, por favor? No se escucha.
I can't hear the translation. I cannot hear the translation.
Can you hear me now?
Sí lo escucho. La
What-
primera palabra que usted dice cuando traduce no se escucha.
I can't hear the first word. Madam President, that maybe if Council waits 3 or 4 moments before asking the question, that may help? There's a delay.
Yes. What was he saying? Okay. I will repeat my question. What was the conclusion? What did you conclude in your report?
My opinion was that although it is true, all of the mining concession holders, as the Constitutional Court said, must pay the royalty for mining because royalties are not taxes. It is also true that stabilization agreements entered into by Peru in the mining sector had a specific provision for administrative stabilization. As an exception, those mining title holders that had made these agreements were protected in their investment projects, which is circumscribed by a feasibility agreement under the contract. When calculating the mining royalty, for the basis of calculation of that royalty and the application of that royalty, they had to bring in the amount corresponding to the stabilized project within the limits of the contract, the agreement.
And the opinion in the opinion that you expressed in the report of April 2005, I'm sorry, is that consistent with MINEM's view of the scope of mining stabilization agreements during the time you worked at MINEM?
That's right. The institutional opinion by the ministry has always been that stabilization agreements only protect the company within the remit of the investment project. You have a specific investment project, and the purpose of it is that the rate of return expected by the investor is not distorted by an act of the prince, by a supervening act.
Thank you, Mr. Isasi. I have no further questions.
Then to claimant for cross-examination.
Madam President, given the technical difficulties and the hearing issues and where we stand in the schedule, we will forego the cross-examination of Mr. Isasi and instead focus on the witnesses who actually came here to New York.
Okay, this is noted. Then we will also not have a recross. But the tribunal.
My only recross is that we're in D.C. as opposed to New York, but that's a very small point.
That's a good point.
Then, Mr. Isasi, we take the opportunity to ask one or the other question, and that to you. With my permission of my co-arbitrators, I just start, and then you will jump in if necessary. So, I follow the chronology of your...
Discúlpeme, no estoy escuchando bien.
I can't hear you very well, Madam President. It's distorted. The voice of the interpreter is distorted.
Que dijo que no iban a interrogar.
So, Mr. Isasi, I was informed that the Zoom technician is trying to solve it because we can hear and see you perfectly well. So it seems to be a problem of the Zoom connection, and we hope to solve it quickly.
Gracias.
Thank you.
Recording stopped.
repente es...
Okay, can we just run a quick test on the Spanish channel?
Sí, mucho mejor.
Yes, much better, thank you.
Better, I assume?
Much better, thank you.
Mucho mejor.
It's much better, says the witness.
Perfect. Then we
Thank
can
you.
proceed, and I will speak.
Recording in progress.
Then we can proceed.
Adelante.
I will speak very slowly so that the translator can follow. And I will also make sufficient breaks
Muy bien.
so that we should not encounter difficulty. But if you have difficulty to understand me, please say so.
Thank you very much.
My first question relates to paragraph 6 of your first witness statement, where you state Minim's position was always that Cerro Verde had to pay royalties on the sales arising from the primary sulfides. We have heard in this arbitration different testimony by Ms. Chapuis, who testified that in a meeting on the 15th of June 2004, so shortly before you joined Minim, there was consensus that Cerro Verde, with its whole concession, would be exempted from royalties. Have you been informed about such meeting?
What is the date again, ma'am?
The date is the 15th of June 2004, so shortly before you joined Minim in your position.
I don't have any news in connection with that statement. All of the evidence I have points to the fact that from the very beginning, when I started working at the Ministry of Energy and Mines, there was a clear consensus that the stabilization agreements only protected in connection with the subject matter of the contract. This had to do with the theory of contracts. We didn't have any specific law stating that. Article 61 of the Constitution protects the subject matter of the contract, the purpose of the contract that cannot be modified by external agents, external factors. That's the idea. We were always aware that the stabilization agreement only protected the purpose of the contract. If you're talking about Cerro Verde, the purpose of the contract was a leaching project that was clearly circumscribed under the feasibility agreement, and under the contract it is an integral part of the agreement. That is the scope of protection. Nothing beyond that. Anything outside the contract is not part of this.
Then I would like to put on screen the document RE 198 and discuss it briefly with Mr. Isazi. This is an email by Ms. Chapuis of 11th of June 2004. Can we put it on screen for the witness, please?
Tendría que aumentarlo porque no lo veo.
It is too small. I can't see it.
It is an email by Ms. Chapuis of June 11, 2004. Can you read the recipients to which this email was directed? Can you see it?
Rosario Padilla, Jaime Chavez Riva, Oswaldo Tovar, Luis Colonna, and Luis Panizo. These were people that were not there when I was there.
So when you started in July 2004, these people had already left?
Let's see. Luis Panizo was part of the Mining Council. Rosario Padilla, perhaps yes. Perhaps she was there at the DGM still. Jaime Chavez Riva, I think he was the advisor to the Vice Minister Polo. He was seconded by the Institute of Mining Concessions. Oswaldo Tovar was the director of mining promotion.
And the email states matter request for, can you maybe also, for me, the English version, can you enlarge it? The email states as matter request for inclusion of the sulfides project in stability agreement of Cerro Verde. Is this legal? Is this a question that was also raised to you at the time?
Please continue.
Is this a question that was posed to you at the time, or would you have expected that it would have been posed to you at the time?
Not at that time, no. I don't think so. I do not recall that a question was posed to me in connection with this specific matter at that time. Now, at some point in time, I have become aware of certain discrepancies that Mr. Polo, the Vice Minister of Mines, had with Ms. Chapuis. She was the DGM, but I wasn't able to understand the scope of those discrepancies.
Sí, recuerdo.
I do recall that on one occasion, Cesar Polo, as Vice Minister of Mining, asked me a question as to my opinion regarding the protection of the provided by the stability agreement. I don't recall that it had to do specifically with primary sulfides, but I do recall quite clearly that the minister at that time, Quijandría, told Cesar Polo, don't worry about that. Let the one who has a fresh mind here analyze the topic and give his opinion. And I clearly stated my opinion, sharing the opinion of Jaime Chavez Riva, of Cesar Polo, an opinion that was shared by Jaime Chavez Riva, Rosario Padilla, I understand, and also the attorneys at the DGM. Rosario Padilla was one of those. All of us thought that the stability agreement was limited exclusively to the investment project that was delimited by the agreement. Therefore, the primary sulfides contract was not included in the leaching agreement. As I say, I do recall that at some point in time afterwards, that issue was raised with me. I always said that primary sulfides was not encompassed in the protection afforded by the stability agreement for the leaching project. Hello, I'm one of the arbitrators. You just mentioned that you came to learn, or you knew that there were discrepancies between Cesar Polo and Ms. Chapuis. Could you explain to us what were those discrepancies and what you knew about them at the time? No, I felt that there was some tension in the relationship between those two persons. I wasn't concerned to find out because these were matters that didn't involve my office. And you didn't know what the position of the Director General for Mining was? The truth is, I don't recall what her position might have been. I assume that there was a discrepancy between them, but I wouldn't be able to explain to you just what it was. About what subject matter it revolved around. So much so that Ms. Chapuis retired from the ministry a short time thereafter.
Then let me turn to a next item, which is the application and extension of the beneficiation concession. Were you involved in this extension of the beneficiation concession, which took place on the 28th of October 2004? Were you consulted on this issue by any means?
The expansion?
Yes, and the application for that was in August 2004, and the decision was rendered in October, end of October 2004. This was the extension of the beneficiation concession to the concentrator. Have you been involved in this issue?
No, because, well, let me explain. In the structure of the Ministry of Energy and Mines, each general directorate had its own legal counsel office and its own technical personnel, and matters such as those would be resolved there. The General Directorate for Legal Advisory Services is an office of legal counsel for the top-level management, the minister, the vice ministers, and the secretary general. So I did not have to be involved in that issue.
If the extension of the beneficiation concession had the effect of bringing the concentrator under the protection of the 1998 Stability Agreement, would this have been an issue in which you would have been involved? Was it of such an importance or significance that then you would have been involved? Or do you only come in when the minister calls you to come in?
Well, let's see. How can I explain it to you? The expansion of operations, mining operations, and the only effect is to authorize that one carry out the activity, but one cannot amend the agreement. One would have had to have incorporated that expansion in order for it to enjoy stability. It would have had to have been included in the agreement. And on that, no doubt they would have had to have consulted with me, because in that case they would be compromising the or involving the minister of the sector, and it's likely that I'd have been consulted. But that's not what happened, because, as I say, the leaching project was clearly definable and distinguishable from the primary sulfides project. If you read in the claim, Cerro Verde says that at a given point in time before deciding to make the investment, they thought about including the primary sulfides project, yet they discarded that. Why? Because it wasn't profitable. That was a business decision. Had they wished to incorporate it in a stability agreement, they would have had to have made a mutual commitment to make a greater investment on a project which at that time they considered would not be profitable. The thing is, many years afterwards, the mineral prices shot upwards, and so it turned out that the sulfides project could at that point be profitable. So they would have had to have asked for a new stability agreement for that project. The thing is, they did not do so because the law on royalties had been approved, so it no longer protected them against anything.
Then I come to a different question relating to paragraph 20 of your second witness statement, where you describe Cerro Verde as a specific case where both a stabilized project and a non-stabilized project coexists within a single concession. Do you know of any other such cases that arose at your time during office, and how the question of royalties was handled in that case? So the specific scenario that you had a stabilized project and a non-stabilized project within one concession? Or are you not aware of other cases?
Can you tell me where I said that? Because at paragraph 20 of which? The second statement?
The second statement, RWS 9. Let me check again. And there at paragraph 20. There you state, furthermore, as I...
No dice nada.
It doesn't say anything. There's a problem here.
Furthermore, as I explained in my first
A ver,
witness statement...
léame, por favor.
Yes, go ahead, read it to me, please.
Furthermore,
Como lo expliqué en mi primera declaración testimonial.
As I explained in my first witness statement.
Exactly.
Ya, el informe de abril.
The report of April 2005 was not referring to specific cases like Cerro Verde, where both a stabilized project and a non-stabilized project coexist within a single concession. I don't know of other cases. I haven't mentioned other cases. I was raising a hypothesis. The matter is quite clear as I see it. A mining concession covers a very large area from anywhere from 100 to 1,000 hectares. Each concession, in this case, they have 3 concessions. Well, a project is carried out on part of the concession over a delimited area of the concession, an investment project. So it may happen, for example, that a company has 2 pits within the same concession. One pit develops a leaching project and enters into a stability agreement, and the other pit is going to extract only concentrates, and it doesn't enter into a stability agreement. It's 2 different objectives. They're 2 totally different projects. The one enjoys stability, and it has a stability agreement. And that one is protected. The one that does not have a stability agreement is not protected. And they're in the same concession. Now, in the case of Cerro Verde, it's the same situation. It's just that successively, within the same concession, there's an initial stage where they say, my objective is to get to the copper cathode, and I'm going to leach. The objective was leaching to finance the leaching project. That ended, and they had discarded continuing to work because they considered it wasn't profitable. Years later, they consider that it is profitable. So at that moment, they should have sought a new stability agreement for that project. There was a possibility in Peruvian law, there was a possibility that such that even if the leaching project was being carried out and had not yet ended, this is what the agreement states specifically, the primary sulfides project could have been incorporated in timely fashion within the original project, for which one would have had to have amended the agreement, and with which the investor would have had to make a new investment. But that had a time frame, and that time frame was prior to execution of the leaching project. Now that time passed for them, and they never asked for a stability agreement, nor that the primary sulfides project, as far as I understand it, be incorporated into the leaching project. So it's the exact same thing of the example I gave of two pits, two operating areas in a single concession, one protected, the other not, as where it's by stages, vertically speaking. In one case it's horizontal, in the other case it's vertical. One protected and the other not.
Then I would have one final follow-up question to you, Mr. Isasi, from my side. This relates to paragraph 23 of your second witness statement, RWS 9. And there you make reference to a list of agreements of guarantees and measures for the promotion of investments. This is an exhibit RE 175. Maybe we can pull this list on screen, and I would kindly request you to explain what this list means, what this is supposed to tell the tribunal. What was the background of this list?
Tengo que leer para recordar.
I have to read to be able to remember, but it says clearly there, yes, of course. The inquiry of April of 2005, as I told you, was an inquiry by SUNAT where we were asked for an opinion regarding the scope of protection provided by stability agreements. And they also asked for a list of all of the contracts or agreements that had been entered into so that SUNAT could evaluate whether they were or were not protected. So we in the Office of Legal Counsel received a list from DGM, which was the one that had the authority to maintain those lists. And together with my report, I submitted the list that I had received from DGM to the SUNAT. And there it clearly says Cerro Verde leaching project, not primary sulfides.
You refer to line 18, where you say, okay, this is Cerro Verde and the project is the leaching project, and the investment was 237 million, and you say this is the expression from Minem that only this leaching project was stabilized. Do I understand you correctly?
That's right.
Then let us just, and I'll go to through two other examples so that I better understand. If we go to line 9, there the company name is Southern Peru Limited. And then as a project, in line 9 it states Electro 1 leaching, investment 118 million. So is your position that it was Minem's and then SUNAT's official position that for Southern Peru Limited also only a leaching project called Electro 1 with an investment of 118 million was stabilized?
No.
I haven't studied that case, and so I couldn't tell you. What I can tell you is that the list did not imply an a priori pronouncement on the part of the DGM or on the part of the Office of Legal Counsel of the Ministry regarding the scope of the agreements. We would send the agreements to the SUNAT because they asked us for a complete list of agreements that had been entered into. The methodology As I said in my statements and in my presentations on multiple occasions to Congress, was that the competence for delimiting or not delimiting and how much to delimit, or rather to the assessment or non-assessment, or how much to assess royalties on these investments, was that SUNAT had to review each case and review each agreement to determine whether there was an administrative stability clause that protected it, because there are some agreements that don't have the administrative stability clause and they're not protected vis-a-vis royalties. So each agreement had to be reviewed, and on that basis one would determine the basis for calculating the royalty. If it had the administrative stability clause, then from those mineral resources or concentrates that were extracted from that mining investment would be subtracted from the basis of calculation, and one would pay the difference. I stated this on multiple occasions to the Congress and in my statements and in my opinions. The thing is that when the inquiry came in the month of April of 2005, it was a general inquiry. We were not asked about who pays and who doesn't pay. We were simply asked, what is the scope of the stability agreements in general with respect to mining royalties, because there had been a judgment by the Constitutional Court that considered that it was thought wasn't sufficiently clear. For example, when SUNAT inquired on 30 March 2005, the judgment of the Constitutional Court had not yet been adopted, and they were drawing up the inquiry. Why? Because the members of the Constitutional Court had been making contradictory statements regarding the legal nature of mining royalties, whether or not it was a tax, whether it was protected by stability. So when I received the inquiry from SUNAT, the judgment had been adopted, and likewise the clarification of the judgment had been adopted. And so I made a general statement, not regarding any specific project, but in general terms, about, well, while what the Constitutional Court said is true, which is to say that all mining concessions, all mining title holders are under the obligation to pay mining royalties, because mining royalties are not a tax and they're not protected by tax stability agreements. Nonetheless, I said, on an exceptional basis, these specific projects, not the concessions, not the companies, these specific projects should be respected insofar as they have an administrative stability clause. Why? Because the mining royalty, if it is not a tax, is consideration for the extraction of the ore, which belongs to the state. Therefore, they're administrative in nature, not tax in nature. If there's an administrative stability clause, then they're protected, but only with respect to the scope of the investment project. I said this clearly at number 17 and in the conclusion of my April 5th, 2005 report.
Thank you very much, Mr. Ezazi. We have no further questions.
Madam President, I have now a few follow-up questions to what you asked.
Madam President, well, respondent would object to claimant's counsel asking any questions at this point. They waived their right to cross-examine Mr. Ezazi.
No. I mean, everybody has the right to ask follow-up questions if the tribunal asks questions. I waived my right to my primary cross-examination.
Well, we maintain our objection. We're in the hands of the tribunal.
But please go ahead, Mr. Praga.
Mr. Ezazi, first of all, good afternoon, buenas tardes. My name is Dietmar Prager. It's a pleasure to meet you, although remotely.
El placer es mío.
Likewise, good afternoon.
You answered in response to a question by the President that it has always been the position of MINEM that stability benefits are limited to an investment project. So I wanted to ask you whether the Mining Council forms part of MINIM.
The Mining Council is an autonomous administrative organ, technically speaking, that it is part of the Ministry of Energy and Mines. It's part of the administrative structure because people are paid by the Ministry of Energy and Mines, but it is an autonomous collegial body.
The Mining Council is the last administrative instance in mining matters.
I don't think that that question has a yes or no answer because of late the powers of the Mining Council have been reduced, and it has very limited functions. I wouldn't be able to tell you this with any precision because it's 20 years since I've been involved in the issue.
Here today, you do not remember whether in 2004 the Mining Council was the last administrative instance for appeals in mining matters. Is that your testimony?
In general, it was the final administrative instance in mining matters, but delimited to certain spheres. In the case of mining royalties, no, because in the case of mining royalties, well, that was entrusted by law expressly to the SUNAT and the Ministry of Economy and Finance and the Tax Tribunal and the Supreme Court in terms of the administrative litigation aspect.
But in your recollection, would you agree with me that the Mining Council was in 2004, is it your recollection now that in 2004 the Mining Council was the last administrative instance in mining matters other than royalties?
Madam President, he's asked that question before and Mr. Sassi just answered it.
Fine, let me ask you the next question. Before you came to your conclusion that the position of MINIM has always been that investment projects are limited
Me está usted poniendo palabras.
You're putting words in my mouth. Excuse me, I have not said what you just said. So I would ask that you please not put words in my mouth because I have come here with a very positive goodwill to be a witness as to the truth. I have no interest in one party or the other winning in this proceeding. I'm a witness as to the truth, and that's what I have sworn to do. What I would say is that the Mining Council was the last administrative instance in certain mining-related subject matter. The scope of that competence I am not familiar with, and I have no reason to know that. It's part of the procedure that's in my statement.
Mr. Sassi, I was about to ask you a question, and the question was, before you came to the conclusion that the position of MINIM has always been that investment projects, that stability guarantees only apply to investment projects, did you review the decisions of the Mining Council on matters of stability agreements?
Line of questioning, I'm not sure how that falls on the questions of the President.
Well, I can tell you how that falls to the question of the President, because he answered in response to the question that it has always been the practice of MINIM. So I'm testing on what he bases that, what kind of information he bases that statement. Mr. Sassi.
No respondo.
So
May I answer? I understood the question perfectly well, and what I can tell you is that I reiterate that the Mining Council was an autonomous body. I reiterate that when I refer to the institutional position of the ministry, I'm referring to the ministry. The Ministry of Energy and Mines, the mining sector, was structured with two subsectors, energy and mining, a vice minister for mining, and below them, certain general directorates. And the Mining Council is not there. And in the ministry, we debated that. Many times we discussed the matter. Many times the institutional position was always the one that I have upheld.
Sassi, you didn't answer my question. Did you look at the practice of the Mining Council before you came to that conclusion? Did you or did you not?
No, no está en mi informe.
No, that is not in my report.
But I wanted to ask you, did you consider or look at the practice of the Mining Council before you came to your conclusion that investment projects are only, that stability benefits are only limited to investment projects?
No. I did not review resolutions by the Mining Council. I reviewed the law, I reviewed the Constitution and all of the legal citations in that report. That's what I recall. This is 20 years after.
Let me ask you to another question that the President asked you, and that was with regard to paragraph 23 of your second report, where there is the list of the stability agreements that was sent, that you said were sent to SUNAT. And I just wanted to make sure that I understood you correctly. And you correct me. Were you saying, when you were asked about the various titles, that the title of the stability agreement, which is reflected here in the second column, that the title of the stability agreements
I'm
does
sorry,
not reflect the scope of the stability agreement?
I'm sorry, that's a mischaracterization. It's not, I will object because the assertion in his question is erroneous as a matter of fact. He said that that's listed as the title of the stability agreement.
Let us pull the list again on screen and then we all see what it states.
Exactly. If somebody could put that on the screen again, it is, here we go. Mr. Sassi, let me take it slowly. Do you see the list here that says project?
Proyecto.
Mm-hmm.
The project that is stabilized. The Cerro Verde project is stabilized. And that is defined under the contract as a Cerro Verde leaching project, and it is limited by a feasibility study. I do not know what your question is. At any rate, that list shows the contract on guarantees and investment measures as required by SUNAT and sent by the General Office of Mining, and as Director General, I conveyed this together with the report. I do not see the doubt, the follow-up doubt the Council has.
Well, Mr. Sassi, you don't know what the question is because you were not waiting until I asked you the question. So here comes my question. Would you agree that the second column that's listed as project contains the titles that you can find in clause 1.1 of each stability agreement?
I do not understand your question.
Let me ask you that way. What is your understanding what the column entitled project shows? Does it show a title of the stability agreement, the name of the project? What is your view on what this column shows.
As a matter of fact, the question should be asked to the General Director of Mining that sent this information. I see the list of agreements, of guarantees, and measures for investment promotion. This is just a list of contracts, agreements. What I see is that the General Director has identified a company or a leaching product, Cerro Verde, for 237 million, and that agrees with the leaching project that is part of the contract and that is already delimited by a feasibility study. I cannot tell you beyond that whether there is a mistake by the director and he assigned a project name to a company or a company to something else. I do not know. That is the list of all of the contracts with guarantees and measures for investment promotion for SUNAT to do their work. And as I understand, they did it.
Look at the third line, Minera Yauricocha. The project is described as Centromin Peru. Is it your position that the stability benefits applied to the entire Centromin Peru company?
I am not here to speak about Centromin. I do not know what the legal situation with Centromin is.
What about line 11? You see that? Sociedad Mineral de Zinc de Cajamarquilla. Is it your position that the stability guarantees applied also to others? And if so, how would the others be identified?
Reitero que yo estoy.
Once again, I am here to speak about the specific Cerro Verde case. I have not been in the mining sector for 20 years, and I have not reviewed the cases of the other companies whose names are there on the screen. I cannot offer you an opinion as you're asking me to do.
Questions?
Respondent has no further questions. Thank you.
Mr. Isasi, then there are no further questions. We thank you very much for being available via video screen, and you are now released as a witness. Thank you.
Le agradezco a usted la atención.
I thank you. Thank you. Good afternoon.
Thank you.
I suggest that we have now a
Puedo salir,
break.
creo, ¿no?
Madam President, may I be heard for a moment? We strongly object to this conduct of counsel for claimant, essentially waiving the right to cross-examine a witness and then spending no less than 15-20 minutes asking questions allegedly arising out of the tribunal's questions, and we reserve our rights in that regard.
If I may respond to that, it is common practice that if the tribunal asks questions, the parties have a right to ask follow-up questions. My questions were clearly based on questions that you asked and answers that Mr. Isasi gave in response. So there is, in our view, absolutely no basis for the objection. And I think it's a practice that our that the other side has also used to follow up on tribunal's questions.
Madam President, I'm not asking for a ruling, and this statement is unwarranted. I was just reserving respondents' rights.
This is noted. The tribunal's suggestion on how to proceed would be that we now start with Mr. Polo, if this is possible, and I'm fine with the respondent. But as we have to end the hearing today really at sharp 5:30, it may well be that we start then with a cross-examination only tomorrow. So it will be the introduction of the witness and the direct, and then you start with cross-examination tomorrow. Is this fine?
Madam President, I don't have a very long direct with Mr. Polo, so I assume within the time frame between now and 5:30 we could start on the cross.
Okay, then we do that, but I just need to say we need to stop sharp at 5:30. You already have an estimate how long your cross-examination of Mr. Polo will be?
Well, if experience from the previous arbitration counts, unless Mr. Polo fundamentally changed his character, he's a very talkative guy.
Madam President, we cannot characterize the conduct of a witness based on a previous hearing. This is inappropriate.
Yeah.
Well,
so we just keep it simple.
Yeah, keeping it simple is we will surely continue tomorrow. And my estimate right now is that it's probably gonna extend into the late morning, depending on how things are going.
Okay, this is noted. Then I would suggest that we right away start with Mr. Polo's testimony and then continue tomorrow.
Recording stopped.
Madam President, I'm sorry I have to intervene before we begin. Yes.
Can the witness stay in the room, or do you? Don't mind?
I don't think it matters.
Okay.
Madam President, Ms. Torreblanca is listed as a witness. She is not listed as a party representative or a member of the legal team, so she has no role to play in the cross-examination of the witnesses. We see that she's sitting next to the cross-examiner, and we believe that is inappropriate. She can stay in the room, but again, she has no role to play in the cross-examination of witnesses, so we invite her to sit somewhere else, not where she'll be whispering in the ears of the cross-examiner or passing notes. Thank you.
Yeah. I mean, Ms. Torreblanca represents Cerro Verde, but the fact that she's sitting next to me right now is purely fortuitous and not intended to be my whisperer, but I think she will be happy to go somewhere else.
For the record, she does not represent Cerro Verde because she's listed in the list of participants as a witness only. So we ask that she moves where she was.
Thank you very much for your cooperation. The problem is solved. Then we can turn to you, Mr. Polo. Welcome. Thank you very much for being here. I introduce briefly the tribunal. My name is Inka Hanefeld. I'm the presiding arbitrator in this arbitration. I'm here with my co-arbitrators, Professor Guido Tavil and Dr. Bernardo Cremades. You have been called as witness by the respondent, by Peru, in these proceedings. So I need to ask you to make a declaration under Article 35 of the arbitration rules that you will speak the truth, and I kindly request you to read it out.
I solemnly declare, upon my honor and conscience, that I shall speak the truth, the whole truth, and nothing but the truth.
Thank you very much. Do you have your witness statements RWS 1 and 8 in front of you?
Yes.
Confirm that these are your witness statements and that they correspond to your recollection, or is there anything you wish to amend or correct?
No. My statements are signed.
Thank you. Then we will turn to the respondent, who will ask you some questions in direct. Then later on you will be questioned by the claimant. We will not manage to complete your testimony today because we have to end the hearing day today at sharp 5:30. So your testimony will continue tomorrow, and then also we have the opportunity to ask you some questions. So I turn to respondent.
Thank you, Madam President. Good afternoon, Mr. Polo. You have the two witness statements in front of you, and you confirmed that they had your signatures. Are the statements based on your personal knowledge and experience?
Yes.
Could you please describe your formal education?
I am a civil engineer. I graduated in 1967 at the National Engineering School of Peru. I am a civil engineer from the National Engineering University of Peru. I graduated in 1967. I'm also a graduate with honors of the Pacific University with a master's degree in business management with specialization in finance. And those would be graduate studies, and I have also studied development and planning of development in France, and then with a PhD level in Peru, and also some other minor studies. I am retired.
What positions did you hold before you retired, particularly in the Ministry of Mines and Energy?
I was Vice Minister of Mines twice, for a total of almost 6 years as Vice Minister under 2 different administrations. And I also worked with 4 ministers, and I renewed the trust twice. That is to say, 5 different people entrusted that position to me during 2 different administrations with Mr. Fujimori and Mr. Toledo.
Could you please explain briefly what the Minister of Mines, Mr. Fernando Sanchez Albavera, asked you to do when you were Vice Minister with respect to the creation of Decree 708?
El viceministro.
The minister, Fernando Sanchez Albavera, and myself trained together at the Planning Institute, and we were familiar with each other. And he told me, given your experience with investment projects and your working in the mining sector, in addition to the academic background, I would like for you to propose some stable rules to promote investment in the mining sector, which is one of our strengths. This would entail guarantees, benefits, and to promote long-term projects or projects with a long maturation period.
As Vice Minister of Mines, what is the scope of a stability agreement?
The stability agreement is thought or designed to give clear instructions and rules for investment projects and also for expansions of projects specifically linked to the project. This is not for the mine title holder, the concession, or the administrative mining unit. The idea was to promote new investments that entailed stable, clear rules.
Mines for a second time, the mining royalty law was enacted. In your view, what is the relationship between the obligation to pay royalties and stabilization agreements?
The stability agreements stabilized based on the approval of feasibility studies, which were attached to the agreements, prevent any impact on the royalties. This is a shield because there is a stabilization of the games of the rules of the game, and this was at Decree 708.
Madam President, I have no further questions.
Hello, good afternoon, Mr. Polo. It's a great pleasure to meet you again. I will be asking you again a series of questions. If you do not understand the question, please ask me to clarify it. And we both have to be careful to respect the translation time and not to talk over an ongoing translation. I'll do my best.
Have you handed out cross binders for at least the witness, but also for us and perhaps the tribunal as well?
We have them already.
Oh, well, you gave it to the right people, but I believe the witness might also want it.
The witness may want to have one as well, yes.
Apologies, we only have for the direct. Sorry, not for the cross.
Okay. Has been a long day. think everyone has the binder, so let's start. Mr. Polo, you testified at the hearing in the SMM Cerro Verde versus Peru case in February, right? On the microphone.
Yes, that is true. And it is also a pleasure to see you again.
Perdón, le voy a sugerir, deje el...
Gracias.
Did you review the transcript of your testimony in the SMM Cerro Verde versus Peru hearing in preparation of this hearing?
Yes, recently.
Did you review the transcript of the testimony of any other witness or expert in the SMM Cerro Verde versus Peru hearing?
En absoluto.
Not at all.
¿Qué quiere decir no?
Okay.
Which translates as no.
Did you review the transcript of the opening statements of the parties in the SMM Cerro Verde versus Peru case, or in this case?
Repasé todo muy rápido.
I reviewed everything very quickly.
Because I asked you two things at once. Did you review the transcript of the opening in the SMM Cerro Verde versus Peru case?
Are you talking about the whole document? Are you talking about all the document in the of the transcript?
A question.
Okay.
You might want to explain what that is, because that's a term that we know, but I'm not sure he knows.
Well, let me ask you that way. You told us that you reviewed the transcript of your testimony in the SMM Cerro Verde case. Did you review any other parts of the transcript of the SMM Cerro Verde hearing, other than your testimony?
Just your questions and my answers.
Okay, so you, for instance, a transcript of the opening statements that the attorneys made at the outset of the hearing?
No.
I did not, no. No, the statements, no. The questions you asked me, the answers I provided. The intervention by respondents' counsel at some points, and that's all I've read.
Can I also ask you, before you signed your witness statements, did you review the witness statements of any of Peru's witnesses?
I do not know of any other witness statement of anyone else.
Let me ask you specifically, did you review the witness statements of Mr. Tovar?
I'm not a lawyer. Perhaps some of the terms are legal and they may confuse me. I knew of the testimonies that were in a binder for the case, and I saw what they opined. I saw those testimonies, but I didn't read them all because it was overwhelming, really. I just saw some of them, only some. And I got an idea. I had my own idea, and I think that that was enough. I didn't go in depth in connection with the testimonies of the respondent or the claimants. Well, I looked at some of the things that the claimants, the respondents said. But I focused on my own things. That was quite enough.
Try not to use any terms that are too much lawyer-like. So please tell me if I do. But can you explain me when you reviewed the witness statements of some of Peru's witnesses?
Before February, before I went to the February hearing. So the testimonies are the set of documents that were given to me, similar to my own testimony. I reviewed some of them, and I think one by Mr. Isasi, Mr. Fleury. I worked with Mr. Fleury, and also some documents related to your expert, the female lawyer, and also from the constitutional experts, but some things, not everything. It was too much to read, not everything. It was impossible to read everything.
So when you say you reviewed those witness statements of, for instance, Mr. Isasi or the constitutional expert, did you review them in preparation of the SMM hearing? Did I understand you correctly?
I did it to get information about that. I was sent all of the testimonies, and I looked at mine in detail, of course, and some other things. That's it. Just to have some idea of things. At the time, I didn't even know that I was going to become a witness. Simply, I looked at what I did, what others did. I reviewed that. That's all.
Okay, I'm a little bit confused. You said this February, but this February you knew that you were a witness. Were you referring to February of this year or to February of a previous year?
The testimonies, I would have had to review them before February. I think before February, of course, I'm talking about the first hearing. Before February, I didn't even know that I was going to be a witness. I just reviewed that, and then I came to know that I was going to be a witness, but I'm not certain. I'm not sure.
Mr. Paul, are you saying that you reviewed those witness statements before you signed your own first witness statement?
No. My witness statement had been signed before. After, I looked at the other ones that I received, and I'm sure that was the case for the others as well. That's what I recall. I wouldn't have been able to prepare my testimony by studying the testimony by others. But if you want me to say that, no, that was not the case.
It was at some point after you submitted your first witness statement. Did you review them before you submitted your second witness statement? Did you review the, just to be precise, did you review the witness statements of Mr. Isasi and the constitutional expert before you submitted your second witness statement?
I don't think so. I have received advice from Respondents Council, Peru, and I have acted always in accordance with their advice, and that's how I've managed things. I've followed the procedure, that's all.
You mentioned specifically the witness statement of Mr. Isasi. Do you recall also having reviewed the witness statement of Mr. Tovar?
I don't think so. I do not recall having reviewed Mr. Tavares. I know them both very well. I've worked with them. I was trying to remember, in connection with Isasi's testimony, and you will recall that I was vice minister 31 years ago. I was trying to remember what I recalled and to look at it also from Isasi's viewpoint.
So if I understand you, sitting here today, you do not recall whether you reviewed Mr. Isasi's witness statement before you wrote your second witness statement or after you wrote your second witness statement?
Let me tell you, I followed the instructions given to me by counsel, and in the order I was given the documents, and at the right time. I didn't pay attention to those things.
Mr. Polo, when you prepared for this hearing, I assume you spent some time meeting with your lawyers to prepare, is that right?
That's correct.
And I think when you prepared for the SMM hearing, the same is true. You spent some time with your lawyers to prepare for the hearing, right?
That's correct.
Yo no había.
I had never been involved in hearings such as this, so this was completely new to me. I was explained the procedure, they explained things to me about the tribunal, etc.
Can you tell us how many hours approximately you spent preparing for each of the 2 hearings?
That's a lot. I wouldn't be able to tell you. Quite a lot. I studied like a maniac.
Muchísimo meaning more than 20 hours for each hearing?
No.
Much more than that. What you want to do, imagine, is to do your best, to be faithful to what you do or what you did rather, and to remember everything. Well, 200 hours, I would think, easily. To the 2 hearings, right? 200 hours.
Hours for each hearing or together?
Together. The second hearing adds more hours because it's the second one, and one wants to recall what one said at the first hearing, what you omitted, what you wanted to clarify, what you wanted to ratify. You wanted to understand the concerns of both parties more and to say, your own truth, what's correct.
100 hours were spent preparing for the hearing and not also writing the witness statements.
No. The procedure for the witness statements, I can explain it to you what it was if you wish.
Asking specifically whether the 200 hours include the time that you spent preparing the witness statements or whether they were just preparing for the hearing.
No.
The preparation of the testimony, that takes a long time. So I prepared for the hearings on the basis of my witness statements and also on the basis of some explanations as to what the procedure is like. And also counsel for respondent asked a few questions and I answered the questions as I always do.
Did Mr. Isasi participate in any of those preparation meetings that you described?
He did not. I worked with counsel, and we did this virtually. At the beginning, I was sharing with them my experience to see whether I was going to become a witness or not. If they were interested in me, then I provided more information as I recollected things and as I added things, and then I found out I was going to be a witness.
Mr. Tovar participate in any of the preparation meetings?
No.
He did not. I dealt directly with counsel.
Did you discuss with Mr. Isasi or with Mr. Tovar the case before you came to testify in this hearing?
I did not. Isasi worked closely with me up until 2005. There are some things that he and I dealt with together, and those were very clear in my mind. The presentations to Congress, to the Constitutional Tribunal, and some public presentations as well.
Well, did you ever discuss some of those facts with Mr. Isasi when you prepared for your testimony? To refresh your memory.
No, I just wanted to ask him because I was confused as to the date in connection with a presentation made by Isasi. It was very clear to me that I had been with him at the Congress, and he said, no, you were no longer the Prime Minister, and he clarified that to me.
How did that happen? Did you call him, or did you meet, or?
It was a phone call. I first spoke to his second-in-command, and I said, okay, that colorful presentation that is very clear, that was prepared, was I the vice minister then when that presentation was made or not? I don't think I was the vice minister, but I thought I was. And he said, no, you were no longer the vice minister. It was Segarra. And Isasi confirmed, you were no longer the vice minister. So there was something that was strange. After being vice minister, the minister asked me to go on as his consultant, as his advisor. So I was just his advisor, and perhaps I thought I participated in that capacity in that presentation, but many, many years have gone by, so you can't really ask me to ascertain those things that I cannot really recall.
Which presentation was that you're referring to now?
It was a presentation that had to do with mining royalties. It had to do with profit reinvestment. There were some Congress people that wanted everyone, all of the companies, without any distinction, to pay royalties. The ministry, Isasi, Chapuis, myself, the minister, we all said that the investment projects that had a stabilization agreement were protected and they should pay no royalties. We said that at the Congress, at the Constitutional Tribunal, and we proposed this in a draft communique. We also discussed this at the offices of the Minister of the Economy and with people of SUNAT were there también. I was also part of the MINEM, and other people were present there at that meeting. The Minister of the Economy people were there. They presided over the meeting.
Other than a conversation with Mr. Isasi about that meeting, anything else that you discussed with him to refresh your memory?
No, but we both knew that we could not speak.
What about with Mr. Tovar? Did you have any discussion about Mr. Tovar, about your testimony?
No.
Not at all. I do not know what I said, and he doesn't know what I said. I do not know what he said.
And I asked you about the preparation for this hearing. When you prepared for the SMM hearing, did you, when you had preparation meetings, was Mr. Isasi, was Mr. Tovar present at any of those meetings?
No, with counsel.
You were exclusively preparing with the lawyers. Sorry. So, exclusively preparing with your lawyers for the meeting, is that your testimony?
Yes, with the lawyers in Lima. We had a meeting.
And did you have a meeting here in Washington with the lawyers as well?
For this hearing and for the other hearing, yes, with counsel. I always met with them when dealing with these issues.
And at the meeting with your lawyers preparing for the SMM case, right? Here in Washington, were any of the, was Mr. Isasi or Mr. Tovar present?
I don't think Isasi was present. I knew that Tovar was present, just him.
So when you say Mr. Tovar was present, are you saying that he was present at the preparation meeting that you attended?
No.
No.
Referring to Mr. Tovar testifying here in Washington.
Yes, I knew that that's what he did.
Mr. Bolo, I will very briefly start to ask you questions about your background. We have to break in 10 minutes. So let me start a little bit about your general background. You became, I think you mentioned it earlier, for the first time Vice Minister for Mines in August 1990, right?
The first time, yes, August 1990, correct.
And the government appointed you to that position on proposal of Mr. Fernando Sanchez Albavera, who was then Minister of Energy and Mines, right?
He recommended that I take that position, yes.
And Mr. Sanchez Albavera was the first Minister of Energy and Mines under the government of Mr. Fujimori, right?
Correct.
So at that time, if we put ourselves back, that was in 1990, by the way, right?
August 1990.
So putting ourselves back in time to August 1990, is it fair to say that Peru's economy was going through a significant economic turmoil?
Yes, there was a very serious economic crisis at the end of the previous administration.
I think you mentioned that last hearing that there was inflation reaching 7,000%. Is that your recollection?
Yes, I have read my statements. Depending on the period you're looking at, you can have enormous inflation rates. They were all enormous. The last 2 years were terrible. I read about enormous inflation rates out of the statement made by a former minister.
And is it fair to say that international financial organizations deem Peru to be an ineligible borrower?
It was ineligible because it was in default. It defaulted its payments.
And Peru was also suffering from domestic terrorism at that time, right?
That is true.
And for sure, terrorist attack, killed thousands of Peruvians, but they also targeted mining companies, right?
That is correct, yes. I was threatened twice.
Why did terrorism focus also on a mining project?
Well, they acted in the Andean areas, in the high areas, and the most important economic force was the mining companies, and also it provided explosives, right? And they considered that all of the workers there were traitors to the cause. They killed them, they stole the explosives, etc.
So is it fair to say that the combination of the financial crisis and of the terrorist attacks had a significant impact on private investment in the mining sector?
That is correct. Also, it had to do with the policy of the former administration.
When you say it also had to do with the policy of the former administration, what do you mean?
Alan Garcia's administration, initially, it created a discriminatory system for the handling of the exchange rate and foreign currency. In spite of the fact that there was a legislative decree 109 that supposedly provided for stability.
I think you mentioned at the SMM hearing that the last important investment in the mining sector was made towards the end of the military government at the end of the 70s in the Cuajone project. Is that still your recollection?
I was thinking about this, and it was signed at the beginning of the military government, and the investment began at the end of the military government. I think the contract was signed in '69, and then production began in 1977. I think so, around that time.
By the time you started as vice minister, that was the last important investment in the mining sector, the Cuajone investment in the 70s. Is that right?
Private mining sector. There were some investments that were made in the state-run companies, such as Tintaya. and Minero Peru, some of them that were related to Cerro Verde.
And you mentioned the government-owned sector. I recall that you used to work for about 10 years in the 1980s for a company called Centromin, right?
Sí.
Yes, 20 years in total. I had a first period as vice minister, and then I worked for Centromin later on as well. 20 years in total.
To the tribunal, what Centromin was?
Centromin was born after the expropriation of Cerro de Pasco Corporation. It was a foreign company that existed in the certain area of Peru, and the largest mining company of Peru. It was expropriated. It went to the hands of the state, and Centromin was created.
So it was a state-owned company.
Yes, it was a state-owned company. Yes, that's right. It was the property of the state.
And I think you mentioned that Centromin was operating a number of mining units.
Yes, 7 mining units with their concentrators and the whole logistics around it under a single unit that was called Centromin. That was the company.
And that was the case in 1990 when you joined as the ministry as vice minister, right? Just so that we place it in time.
Sí.
Yes, that's true.
And did Centromin also own companies that were not active in the mining sector?
It had some projects. Toromocho, for example, I recall. It wasn't a mine yet, but it was a project that was there. And then there were others that I cannot recall at this point in time.
But my question was specifically whether Centromin also owned companies that were not active in the mining sector, non-mining activities.
Yes, there were some activities that were carried out by Centromin, but there were related companies, Renasa, Explosives, EXA, Reactivos Nacionales, COMSA, which was a construction company in the mining sector. We're talking about 30-some years that have gone by already.
And I recall you mentioned, and you correct me if I say this wrong, but when you worked as vice minister, you were on loan from Centromin.
Yes, that's right. It was a very usual thing. They did that to reinforce the people who worked in the central government.
And that means that Centromin was paying your salary. Is that correct?
Sí.
Yes, I received my salary from Centromin, the same salary that I had without being the vice minister.
And after you concluded your first term as vice minister, you went back to Centromin as an advisor to the president. Is that correct?
That is correct.
I'm conscious of the time, no worries. Is it also correct that Centromin let me place again in the time, in 1990, 1991, was intending, sorry, let me rephrase that. Is it correct that in 1991, the government intended to privatize Centromin's assets in a comprehensive sale? At
the beginning, it wasn't comprehensive in nature. I think there was a project 647 or something like that. It was a draft law, and the initial position was for the takeover to include the majority of things. We hoped to have majority private participation via a capital contribution.
Okay, thank you very much. I will stop for today, conscious of the time.
Thank you very much. So we will see you again tomorrow. Do the parties have any issues to raise before we conclude?
None on behalf of claimant.
None on behalf of respondent.
Thank you very much. Then we conclude the day and see you tomorrow morning.